Hello everyone, this is immigration lawyer Mustafa Cetin. Today I will be covering everything you need to know about asylum. Start with the merits, the basics of an asylum claim, what are the elements required to qualify for asylum, and then we'll talk about the procedure involved with the asylum. We'll break it down to affirmative asylum, definitive asylum. After watching this video, it will be as if you had a consultation with me. That's what I'm going for. So without further ado, let's get to it. I've been dealing with asylum for about 7-8 years now. We start at the most basic level, where you apply with the USCIS as an immigration benefit, or we deal with it at the court level, where asylum is a defense, as a form of removal relief, or we take it all the way up to the Federal Court of Appeals at the end of the administrative process, and where we argue for asylum relief, where the asylum laws are interpreted. It becomes the law of the land, and it is applicable to everyone deciding, adjudicating asylum at every level. We've been doing this for a while, and I'm considering myself an expert, so consider this as a free consultation. What is asylum? It could be traced back all the way to the Second World War, and the international standards are established around by the time United Nations is established. So basic idea is, if someone is being prosecuted, what is protected under human rights, they should be afforded protection, asylum protection. Each country has a different way of interpreting these laws. Devil is in the details. We'll be covering the way it is interpreted under US law. What is asylum under US law? It is a legal protection given by the US government to people. Who are these people? First of all, they need to be outside of their home country. They're afraid to return due to serious harm or threats, and harm must be based on these 5 protected grounds, the human rights, because of their race, religion, nationality, political opinion, membership in a particular social group, which could be interpreted as gender, sexual orientation, or something unique like victims of domestic violence in a certain country. At this juncture, I should also say asylum is discretionary. There's a different form of asylum called withholding of removal, but at its core, it is discretionary. They look for these standards, but you may not give it at the end of the decision. So what is persecution? Persecution is a term of art we utilize for asylum purposes, and it's about being subjected to harm because of these protected grounds and ill treatment you receive. It could be in the form of past persecution, something that happened in the past, or it could be a well-founded fear of persecution. You're arguing something is going to happen to you. In the case of past persecution, the assumption is if something that's happened in the past, it is likely to repeat, which shifts the burden of proof to the government, where they have to argue that they have to prove that it's not going to repeat, but we'll get to that. What could be persecution? It could be threat. It could be physical abuse, physical harm, like torture or abuse. It could be imprisonment. Or it could be physical violence, like we said, or serious discrimination. You need to talk to an expert to understand if what happened to you or what you're afraid of could qualify for asylum, because it is very technical. There is case law on interpreting different circumstances. It is imperative that you need to talk to an expert to have a complete understanding, complete assessment of your circumstances. To qualify for asylum, there needs to exist something called, another term of art, nexus. This threat of harm or harm that happened that is assumed to be continuing needs to be based on one of the protected grounds. This is what we call nexus. We're going to break down what are these protected grounds and provide a couple examples for better understanding. So there is race, someone's skin color or background, or indigenous groups in a certain country, certain area. I should say most of the time these protected groups comes with groups of people that are minority in this specific country that we're dealing with. There is race and there is religion, someone's faith, or it could be someone's lack of faith. There is nationality. This is not very common. One example I can think of that was historically utilized was the dissolution of the USSR, Soviet Union. There were certain groups of people who were not afforded citizenship because of their backgrounds, but this is not very common, I should say that. There is also political opinion. Political opinion is very common, probably most common ground, because asylum is usually called political asylum. So what is political opinion? Political opinion could be direct political activity or a certain idea, a certain belief, a certain type of resolution, a certain type of conviction that you have. I recall a case from Africa where I had a client. The idea was that, the political opinion that we were able to successfully argue was that they would teach trade skills to anyone, regardless of their sexual orientation, regardless of their background, ethnicity, etc. We were able to successfully argue that this is a political opinion. Sometimes the political opinion is not direct. There is something called an imputed political opinion, where the persecutor, it could be the government, is imputing this opinion to you. They're saying if you had this and that, if you're affiliation with this group, or if you're doing this, you have this imputed political opinion. That is also a very common way of successfully arguing for asylum. There is the most complicated one, the most unusual one, the particular social group. This is a little bit tricky because it could be straightforward as gender. It could be someone being persecuted because of their sexual orientation. It could be like family ties. It could be membership in a defined group, but this is very technical. It's on top of asylum's regular complexity. There is another layer of case law that applies to a particular social group. One example I can think of could be in the context of South America, Central America. Landowners are being targeted in Central America. So landowners could be a particular social group. There's a lot of case law that is applicable. Like we said, the harm or threat of harm must be based on one of these protected grounds. You cannot just say, oh, I'm afraid of being harmed. Otherwise, you don't qualify for asylum, unfortunately. Let's talk a little bit about past persecution. Past persecution is something that's happened in the past, and we said there's going to be an assumption that it will repeat. To qualify for past persecution, there's a threshold, a certain level. There's a lot of case law on this that interprets what will be an appropriate threshold for someone to successfully argue that they had past persecution. First of all, it is past harm. It is serious and credible. Specific as physical harm. Broken body parts, unfortunately. Serious physical harm, serious violence, being physically abused could qualify as past persecution, or it could be very serious threats, or it could be imprisonment. And like I said, this is something that you need to assess with a professional. Without a full, complete assessment, there's no way to understand if you have a solid, strong case or not. It could be something like severe discrimination, a systematic discrimination, where you are pretty much subjected to civil death. You cannot find a job, you cannot lead on with your life. Something like that is not easy to prove, but another type of case that we were able to successfully get approved. What type of evidence? Police reports, medical records. We're all interested in this. We're interested in statements from witnesses, and most importantly, maybe, the personal testimony of the individual involved. Because for asylum purposes, credibility of the individual applying for asylum is the most important thing. What about fear of future persecution? There's a term of art, there's a landmark case called Mogherabi. And under this case law, there's a Mogherabi test. We use this to assess the likelihood of a successful fear of future persecution. That found a fear of persecution claim. So let's break it down. For Mogherabi test to be successful, you need to have a trait, something like a political opinion, a characteristic, something like religion, that a persecutor is trying to, going after. They're going after this characteristic. And another element is, does the persecutor know you have this trait? Another element is ability of the persecutor to harm you. In the case of a government, sometimes this is very obvious. So we don't need to try very hard meeting this element. Or it could be a private group, radicals in a certain country. And in that case, we have to try extra hard to show that they're able to persecute you, because the counter-argument could always be that, oh, you're safe. Yes, there is this threat, but you're safe. The country is protecting you. That would be something that would merit the denial of the asylum claim. And last of all, inclination. Is the persecutor likely to harm you? There's been trend that's been going on. Was it a one-time occasion? Was it specific to a certain time period? Or is it ongoing? That's another thing. Unfortunately, we will talk about it, asylum process sometimes could take years. And when that happens, the inclination could be no longer there. That could affect the prospects of securing asylum. Like we said, persecutor is not only the government. Sometimes private individuals, private actors could be the persecutors. But in the case of an authority, government being the persecutor, we don't have to try to prove that they are able to persecute you. But when there's a private actor, another element we need to successfully argue is this government cannot be or will not be controlled by the government. So there's a private actor, there's a group of people. In the case of civil conflicts, the government is not able to stop them. they don't have enough police forces or security forces, or there's a civil conflict going on and they don't have control over the country. Or in the case of a politically aligned government which share the same beliefs, same radical beliefs, they couldn't care less. They don't want to do anything about that individuals. That could be another way of qualifying for asylum. There are certain standards, procedural standards that applies to asylum that might be reason for denying someone asylum. First of all, like I said, it is discretionary. There's no guarantee even if you meet these standards, you will be granted asylum. But there are certain rules that are solidified to account for certain circumstances that would merit denying asylum. One of them, maybe the most common one, is applying for asylum after 1 year. If you apply for asylum past 1 year, you're not supposed to, there's a presumption that your asylum claim is not valid. So that bars you from asylum. There are exceptions to it. There are many cases that we were able to successfully argue that an exception applies, but as a general rule of thumb, you're supposed to apply within 1 year of arriving in the US. If you have committed crimes, or if you persecuted others, that is another reason to be denied asylum. If you had paramilitary training, if you had a militia training, and if you were involved in certain type of activities, that is another reason, although not common, to be denied asylum. And another very common reason is firm resettlement. If you have the citizenship of another country, or if you have been living in a certain country with permanent status for a long time, that is another ground for you to be denied asylum. We already went through this. Firm resettlement. If you lived in a country long time, and if you settled in that country, if you have permanent status, that might be a reason for not granting someone asylum. There's also something called safe relocation. If you are able to live within a certain part of the country, that might be another reason for asylum not to be granted. We already covered 1 year rule. So there is another term of art called availing yourself to the protection of the country. Getting a passport from that country, or getting certain help, or voluntarily returning to that country could be one of the reasons to be denied asylum. That is, when we are doing a full assessment, these are one of the things that we look for. There's a silver lining though. There's a landmark court case called INS v. Cardoza that says the probability level of a harm happening is not supposed to be very high. It could be as low as 10%. The likelihood of harm happening could be as low as 10% to qualify for asylum, so that is an important distinction. Let's talk about the procedure. Like I said, there is the affirmative level where you apply with USCIS after entering the country with status. You file the I-589 form. There's a process involved with that. We're going to talk about that now. This process starts with the filing of Form I-589. Then there is a biometrics interview. They take your fingerprints and your pictures, put that in their system. The next step is an interview, or in the case of defensive asylum, a court hearing, a trial, an individual hearing, and then there's a decision. Unfortunately, this process could take a very long time, as long as years. And it may sound ridiculous, but there are cases that goes all the way up to 5, 10 or more years, unfortunately. Let's talk about the process with the USCIS. You applied by filing the I-589 application, and you're dealing with USCIS asylum offices, and the next step is an interview. So to give you an idea as to how different this could turn out, during the course of the prior Biden administration, approximately 90–95% of the asylum applications we filed affirmatively like this were not being scheduled for an interview. That would translate to years of wait. So from the time you applied, from the time you get your interview, sometimes it could be years. And based on the current administration, Trump administration, they interpreted this as a loophole. They did not want people to abuse the asylum system, so they are, as best as they can, scheduling interviews as soon as possible, so that people without an asylum claim, they are not in a position to file for asylum and gain time for years while they wait for their interview. So what happens after interview? There is the decision, and there are two different scenarios. One is you have another immigration status, like student status, like H-1B or tourist visa, depending on the timeline of when you entered the country. If you have status at the time your decision is made, like I said, decision could take a very long time. There are two scenarios. Approval, which is happy ending. Approval means you get asylum 1 year after you apply for permanent residency. After getting permanent residency, 4 years later, you qualify for citizenship. If you are not approved and you have status, the next step is notice of intent to deny. They came up with a preliminary decision, and then you answer to this, and after that, again, there could be an approval or you could be denied. Denial means, in this case, denial is not final because there is a provision that says the final say for asylum purposes has to be by an immigration judge. Let's talk about what happens when someone is not in status. Let's say you applied. You had your interview in about 6 months or a year or 2, and you entered the country with tourist visa, and you don't have status anymore. What are the possibilities? One possibility is happy ending, approval. The other possibility is, unfortunately, referral to immigration court. So, like we said, if your application is not being approved, then USCIS cannot decide your asylum application definitively. That has to be done by an immigration court in the defensive setting. That's why they have to refer you to immigration court by issuing a notice to appear, NTA. Let's talk about what is that about and how asylum is sought as a defense at the immigration court proceedings. This is called, another term for it, removal proceedings. This happens before the Executive Office of Immigration Review, and it is another administrative branch of the government. It's not technically a part of the court system. Let's say you entered the country without a status. You could be immediately placed in removal proceedings, or you could apply for asylum, or let's say you had another status and you went out of status, and it's happening very common nowadays. You are being placed in removal proceedings. The government is not in a position to just up and send you from this country. They have to follow due process. That is a protection of the US Constitution, and the way this protection is solidified is within removal proceedings. There's an immigration judge, the USCIS, which initially, if you're applying for asylum like that, was deciding your asylum application. Now, another branch of the sister organization to the USCIS, ICE, Immigration and Customs Enforcement, another branch of the Department of Homeland Security, is now prosecuting your asylum case. And you are using asylum as a form of defense, as a form of removal relief. Removal proceedings start with master calendar hearing. This is the procedural hearing where, government has to prove that you are removable from the country, and 90% of the time, we don't argue with the government in terms of removability because there is a type of removal relief like asylum. This is purely procedural, and a master calendar hearing could be done in writing. You can do written pleadings, and you could be moving forward to the next step without a hearing. But one thing to understand is this process is happening at a very significant level, and it is taking a very, very long time. So immigration court is about, there is no average timeline, but right now there are a lot of immigration court cases. Approximate number right now is more than 3 million. And that means that there's a significant backlog. The number of immigration judges available and the number of prosecutors, lawyers arguing for the government is very, very limited. It is increasing. There was even a talk of having military judges, military lawyers, working as temporary immigration judges, but to say the least, the system is stretched and it is backlogged. So there's a very good chance that after you have your asylum application, let's say you're referred to court, you had your master calendar hearing, your individual hearing could be many years down the road. It could be a couple years, it could be more, 3 years, 4 years, 5 years, depending on how busy you are, how busy your immigration judge is, and how full their docket is. Let's say at a given location now, like New York or New Jersey, an immigration judge is probably giving out an asylum hearing, an individual hearing, the trial date for about 2 to 3 years out. With introduction of more judges, that could change, but the biggest problem here is, unlike many other parts of the US court system, there is no settlement. You have to have a trial. That's why there's a significant number of cases that has to be decided, and that creates a logistical nightmare. What happens at the end of your hearing? You have your lawyer representing you, you argue your case. Government might take a position to not object to your circumstances. If they do, it is up to the immigration judge to decide your case, and in the case of asylum, there are 2 possibilities. You're approved or you're denied. If your application is denied, that doesn't mean it is final. You have the right to appeal. And at this level, the appeal is procedural and administrative. One step up to Board of Immigration Appeals, BIA. BIA is also part of EOIR, Executive Office of Immigration Review. And if the BIA affirms the immigration judge's decisions, which is unfortunately nowadays very, very common, you get a final deportation order. At this point, you do have another option. Within 30 days, you can take this decision by filing a petition for review to the relevant Court of Appeals. At this juncture, it is not administrative anymore. You are going all the way up to the federal court. You have one final chance to argue that there was something wrong with the procedure that applied to you, or the decision is misinterpreting the law. Let's talk about that happy ending. What happens if you're granted asylum? First of all, you can live and work in the US. After 1 year, you apply for a green card, and I can say, even if before you get your green card, your circumstances are very similar to someone who has a green card. You get permanent status. Asylum is not necessarily temporary. You're not supposed to leave the country without permission, and under no circumstances, like we said earlier, you're not supposed to go back to the country of origin because you're seeking asylum from that country and you're not supposed to be able to travel to that country. So if you do, that is likely to trigger problems, and before you get your green card, asylum can be taken back, unfortunately. If you had family members accompanying you, they're granted asylum with you, and if they're not with you, you can petition them to join you after being granted asylum. With that, I'm going to wrap up the basics. If you have any questions, please feel free to reach out and we'll be in touch to discuss further. Thank you for listening and enjoy this free consultation. Spread the word. If you think someone who can benefit from this video, feel free to share around and they can make better informed decision after learning about the process. Thank you.